is section 114, titled Restricting the Use of Chokeholds. My testimony in this part is going to rely a lot on a policy report by the Brennan Center for Justice that they issued last April, titled Protecting Against Police Brutality and Official Misconduct. And so the other thing that this section does is it changes the standard for a prosecution under this from willfully to knowingly or recklessly. This is the section of law that federal prosecutors can use to bring criminal charges against government officials acting under the color of law for violating civil rights. This is the law that the police officers in the George Floyd murder are being charged with right now. They have a higher burden of proof, willfully. The prosecutor is going to have to prove that they willfully violated his rights. A little bit of history on this law. This is from Reconstruction after the Civil War, under the authority of the 13th, 14th, and 15th Amendments to the Constitution to protect the civil rights of former slaves as they began to exercise their rights as free citizens of the United States. There were many violations of those civil rights. And so Congress passed this law, and it was used to prosecute for a while. But in 1945, a case that sort of changed the way the prosecutors used it. That was the case of Screws versus the United States. And it was the Supreme Court ruled on this, and I'll just kind of paraphrase from their description of the case. And they said the case involved a shocking and revolting episode in law enforcement. The petitioner was the sheriff of Baker County, Screws, the sheriff of Baker County, Georgia, and there was some evidence that he held a grudge against Robert Hall, a young black man of about 30 years of age. And so Sheriff Screws got a special deputy and a policeman, and they went to arrest Robert Hall late one night on the charge of theft of a tire. And so they handcuffed him, threw him in the squad car, took him to the courthouse. And when they got him out of the car, they began beating him with their fists and with a solid bar blackjack, about 8 inches long, weighed about 2 pounds. And they beat the handcuffed man for 10 minutes, 15 minutes, 20 minutes, 30 minutes, until finally he was unconscious. And then they dragged him by his feet into the jail, threw him on the floor, and left him there. And like Eric Gardner, 70 years later, eventually, an ambulance came, but it was too late. The man never regained consciousness and was dead and died within an hour. And so Sheriff Screws was charged and prosecuted for this murder and was convicted, but he appealed it all the way up to the Supreme Court. And the Supreme Court overturned his conviction and said, quote, in view of our construction of the word willfully, the jury should have been further instructed that it was not sufficient that the petitioners had a generally bad purpose. To convict, it was necessary for them to find that the petitioners had the purpose to deprive the prisoner of a constitutional right, e.g., the right to be tried by a court, rather than by ordeal. And in determining whether that requisite bad purpose was present, the jury would be entitled to consider all of the attendant circumstances, the malice of the petitioners, the weapons used in the assault, its character, its duration, the provocation, if any, and the like. And so because they felt that there wasn't sufficient evidence that they willfully intended to deprive him of his right as they beat him to death, they overturned the conviction. And since that time, this higher standard has led to less prosecutions under this section of law. And so Section 114 of the George Floyd Justice Act, this section is also taken from the George Floyd Justice and Policing Act passed by Congress, by the House last year. It would replace willfully with knowingly or recklessly. And this would change the burden of proof that the prosecutors would have to meet in order to convict someone of a crime. Under the standard of willfully, The jury must find that the defendant acted with knowledge that one's conduct is unlawful and with the intent to do something the law forbids. But if under the standard of knowingly, only necessary to conclude that the defendant acted knowingly, that it was done intentionally and voluntarily, and not because of ignorance, mistake, accident, or carelessly. And then the standard for recklessly is the jury must find that the defendant act while consciously disregarding a substantial and unjustifiable risk that the material element exists or will result from his conduct. And so with the inclusion of the specific prohibited conduct in the proposed statute, by changing those standards, it would reduce the level of intent required for a jury to find a defendant guilty while for engaging in prohibited conduct under Section 242 of Title 18. Federal law was there for a reason to help make sure that violations of our civil rights could be prosecuted, and to the extent that they are falling through the cracks because of this higher standard affirmed by the Supreme Court, it is appropriate for Congress to step in and bring it back to where this law can be used to protect American citizens from abuse of authority under the color of law. And Mr. Chair, I guess that concludes my testimony for Section 114.